Okay, let's get started. We'll be done here within the hour, I promise. My name is Briant Sikorski. I'm an independent financial planner and wealth advisor with Stratos Wealth Partners. As a wealth advisor, I help clients work toward achieving their financial goals. And some of the things I usually do involve planning, such as financial, insurance, retirement income or education savings planning, asset and income protection through life, disability, and long-term care insurance, investment management, including brokerage and advisory investment accounts consisting of stocks, bonds, funds, and exchange-traded funds, and tax-deferred retirement income strategies, including fixed index and variable annuity products, as well as IRAs and 401ks. Now, today we're going to discuss, and I was teasing a little bit earlier that I have an attorney on line and I'm not. So I want to emphasize that I am not an attorney. Okay, I may play one on TV, but I'm not an attorney. So what I'm sharing with you today is, if you want to call it, publicly available information about the topic of estate planning. So this is not a presentation designed to help you specifically complete your will or your trust or your estate plan in any way, shape, or form. It's to help you pull together the list of important information and questions that you want to take with you when you go see your attorney. Okay, so with that, I will show you on first off on the screen here we have a lovely picture taken. This is my website, but a lovely picture taken in summer. It does not look like that now out here, number one. Number two is, I thought this is kind of interesting as I'm developing this presentation. You always see these articles about people who have died without a will, and I looked it up, and I was shocked at how many there are. Most recently, I'm from Detroit myself, and here is the Queen of Soul. And, Aretha Franklin, for goodness gracious sake, did not have a will. So when she passed away, her four sons filed a document with the probate court calling themselves interested parties concerning her estate, estimated to be worth over $80 million. Now, this is a key point here. It says in the next paragraph, Michigan law dictates the estate of an unmarried person must be divided equally between their children. Her decision to leave out an official will may have song collaborators and distant relatives fighting for a piece of the inheritance. Okay, hang on a second. I want to unmute Doug here. Go ahead.
I was just going to ask if you could mute everybody because somebody's making a lot of noise in the background.
Okay, I'll try to do that. Thank you. If anybody is not muted, please do me a favor and be quiet. So I've got everybody muted now. All right, so here's the Queen of Soul. Here we got $80 million. I don't know about you, but I might fight for a piece of that if I was one of her relatives. Here we have the King of Pop. So we got the Queen of Soul and the King of Pop. He did have a will, but it was considered invalid by several family members. Abraham Lincoln didn't have a will, although it did work out for him, to make a long story short. Here we go. Must be all these musician types. Prince died in 2016. His siblings stated that the Purple Rain singer did not have a legitimate will in place. A long legal battle is expected, but documentary filmmaker Ian Halperin believes that a valid will exists somewhere in Toronto. Well, that's good. I'm glad he's narrowed it down to Toronto. I guess we'll go door to door and look for that will. Kurt Cobain, another singer. Why am I shocked? His entertainment lawyer has stated that Kurt's will was incomplete as he wanted Courtney Love taken out of it. The ambiguity has led to many legal battles between Love and Cobain's Nirvana bandmates. Finally, a non-singer, Martin Luther King, finally. Amy, okay, we're back to singers again. Amy Whitehouse died without a will stating what to do with her $6.7 million estate. Her assets went to her closest living relatives, her parents, Mitch and Janice. Well, maybe she didn't want anything to go to Mitch and Janice, okay? But, oh my God, another singer, Jimi Hendrix. Well, I don't know about Tupac here. He died without a will, but his mother stepped in and set up a trust to protect his legacy. He was actually in debt at the time of his death, but Afeni grew his estate to over $40 million. This is his mom. Okay, now we got actors: Heath Ledger. Back to singers: Bob Marley, Howard Hughes. And these are just fascinating. Marvin Gaye, back to singers. I think if you're a singer, you are inherently not allowed to have a will or something, or these artist types. Pablo Picasso. So why do we care about that? Well, I'm going to jump over to our presentation here and bring that up. And I just found it was fascinating how many people did not have a will. You know, noteworthy people with tons of money. So we're going to talk about this topic today, which is, I'm going to move my little window there so I can see my own notes, for heaven's sakes. There we go. Again, estate planning basics. We're going to cover that. We're going to talk about wills and probate, trusts, alternate decision makers, and what to do next, how to get you started. Okay? So this is really key because I think a lot of people have a tendency to think that it's kind of funny, I'm thinking, is that they think that estate planning is really only for the wealthy. But here we've just given you a whole bunch of examples of wealthy people who haven't done it. So I can assure you it's not just for the wealthy. And it's the key to making sure that everything you work for all your life is passed on according to your wishes. And these really help resolve up front a lot of questions and a lot of difficult decisions ahead of time so they don't become an issue for you or your family later on, which is a real problem. Okay. Come on, slide 2. There we go. So estate planning can be a complex undertaking involving complicated legal documents, numerous tax considerations, and difficult personal decisions. But today, we're going to talk about how to help you make informed decisions as you take that step to put your documents together. Okay? So we're looking at the benefits of estate planning, examine important planning tools such as wills and trusts, and discuss how to turn your assets over to another person. An estate plan provides a strategy to conserve assets when you are alive and distribute them after you die. Your estate plan can outline who will manage the settlement of your estate and who will manage the affairs of any children who are minors. Elderly parents, disabled children, and gifts to your favorite charity are special situations that can also be managed. The key to a successful estate plan is finding the right attorney and advisor to work with you. And people will ask me oftentimes, well, geez, why do I need an attorney? I can go online, I can do this, blah, blah, blah. And I guess I suppose to some extent that's true. I'm almost worried to some extent that having a bad estate plan is worse than having no estate plan at all, because at least no estate plan at all will have some state guidelines, whereas a badly constructed will has no boundaries to it, no bumper guards to it. So there was a joke I heard one time about a guy who used to work, for a shipping company, and they were contracted to the Navy, and this ship would not run. I'm terrible at jokes, but they called this guy in. He took this mallet and he went over to this ship and he banged on this spot on the hull, and the engine started up and the ship worked great. And he sent him a bill for $10,000. And they said, oh my God, you can't charge us $10,000. You got to give us an invoice. And he wrote down $50 to travel to the location and $9,950 knowing where to hit the hammer, where to hit the hull. And I think that's kind of true to both investment advisors and attorneys. Sure, you can find the little tools, you can go and invest online, but the key here is making sure that the document or the investments, in my case, are structured in such a fashion that they meet your goals and objectives. And no do-it-yourselfer is going to, or no online program is going to do that for you. So what we're trying to do is to avoid having the courts make decisions about your estate. We're trying to minimize legal complications and estate settlement costs. We're trying to make sure that we're taking into account what tax considerations are germane to your specific situation. So as you might expect, with the government involved in this in one way, shape, or another, the government will want a piece of your estate when you pass away. So in 2018, the estate tax exemption is a little over, here is $11,180,000 per person, and annual gifting is available to the tune of about $15,000 per year. So this exemption means that your estate can grow to, as an individual, can grow to $11 million before it really gets taxed upon your death. Now, this was not the case in just the last 10 or 15 years. There were times when the estate tax exemption was everything from a little over $1 million to unlimited. Now, also, just as a FYI, there is no or an unlimited exemption for any federal tax that is going to go to your spouse. Okay, and it's also the case for any property that you leave to a tax-exempt charity. Number one. So number two is probably no big surprise. We also have some states. You're like, holy cow, we've got the federal tax or the tax that could be as much as a bracket at 40% for anything above the exemption. And then on top of it, we have some states that impose both estate, which is 12 states, or inheritance taxes. What state estate taxes are the same thing, that before money can get transferred from a deceased party to you, the estate has to pay the federal, if there is any, and the state estate taxes, number one. And then number two, some states also assess an inheritance tax, which means that if someone inherits money, they themselves also have to be may be liable for some tax. So it can really be incredible the amount of money that could come out of your estate if you do not plan things ahead appropriately. So with that, I jump back here. We look at some of the tools that we can employ, and those include wills, trusts, gifting, life insurance, and joint ownership of property. Now we're going to go through each of these kind of, one by one. All right. So number one, also, this is great point. Naming beneficiaries. Goodness gracious. I actually have a personal experience that I can share with you here. But if you think about it, your individual retirement account, your 401k through your employer, your pension plan through your employer, any life insurance policy that you may own, each of these has a beneficiary. And this is something I do every year with my clients as we review their named beneficiaries, because if you have an IRA, named to one person and a 401k going to another person, you can really confuse matters quite readily, or if you overlook updating these beneficiary designations. So my personal experience is I had just gotten into the industry a number of years ago, and there was an individual, a guy, who got married the first time and had no children from that first marriage, and then remarried and had 4 kids from the second marriage. And he had a life insurance policy, and he died. And who do you think got the money? Well, 9 times out of 10, people will say, oh, the first wife. And I'll say no. And then about 2 more out of 10 will say, well, the second wife or the kids. And I'll say no. It's actually mom. He took out the policy before he was married and named his mother as beneficiary and never got around to changing the beneficiary through his first 2 marriages, or to his impending marriages, excuse me. So the money went to his mom, and his mom said that she never really cared for his wives anyways, and that her grandkids were brats, and she just kept all the money. So, something to think about. So we don't want to have things like outdated 401k plan beneficiaries. The wishes may not be carried out according to your own objectives, your own intentions. So here, this is an example of Jane. When she first enrolled in her employer's 401k plan, she named her children as primary beneficiaries and her husband as secondary beneficiary. Her husband agreed to the designation and consented to it in writing. Her first husband died, and Jane eventually remarried, but she never updated her beneficiary selection after she married her second husband. Upon her death, Jane's substantial retirement account went to her second husband because many 401k plans require that a spouse is automatically the primary beneficiary unless someone else is designated and the spouse consents in writing. Jane's new husband never waived his right as primary beneficiary. So again, you can see how state laws, 401k plan laws, federal laws can all play a role in the implementation of your estate plan. Some things to keep in mind, when putting a plan together. Number one is think twice about naming children as beneficiaries. Most insurance policies and investment plans retirement plans, will not pay benefits to minors without a court-appointed guardian or trustee. Similarly, be careful about naming older beneficiaries. Again, they may not be competent to handle that money effectively. So you could consider naming a trust or charity as a beneficiary, which gives you more flexibility as to whom your name and allows you to spell out what exact wishes you have. Rules regarding beneficiary naming are different for each situation, so be sure to review them carefully. For example, IRAs allow anyone to be named as primary beneficiary, but as we saw in our last example, many 401k plans require that a spouse be the primary beneficiary unless waived in writing. When reviewing estate plans, it's imperative to readjust all beneficiary designations so that the entire estate plan flows smoothly. Be aware that outdated beneficiary designations could misdirect the intended flow of an entire estate plan. Outdated beneficiary information is not uncommon. Important life events such as marriage or remarriage may cause your wishes to change. Now, the most basic of all estate planning tools is known as a will. And a will is nothing more than a legal document that explains what you want done with your property and provides instruction on other matters when you die. The will does not take effect until you die and may be changed or revoked at any time while you are living. An effective will should do a few basic things. It should name an executor, the legal title for someone who will administer your estate after death. You should also name a guardian if you have minor children, and it should spell out how you want your property distributed as specifically as possible. With a will, you decide how your estate will be split among beneficiaries. If you die without a will, your estate will be divided according to the laws of your state and not your wishes. When you leave property to your heirs in a will, it must go through probate. Probate is a legal process by which your will is proved to be valid in court. During probate, your assets are inventoried, potential heirs are notified, creditors are paid off, and tax returns are filed. Whatever's left after that process is distributed to your heirs, and in many cases, a significant amount can be lost due to legal fees, executors, court administrators, and others, particularly if there's disputes within the document itself. Depending on the complexity of your estate and the efficiency of the probate court, It could take anywhere from just a few months to as many as several years for your beneficiaries to receive their inheritances. In most cases, an executor named in the will is responsible for seeing that your wishes are carried out. Given these drawbacks of probate, and I've heard I've got clients all over the country, and I've heard issues of probate being nothing to worry about to like, oh my God. So it seems to be more of a, I hate to say, a case by case, city by city, county by county kind of experience. So it's not surprising that many people seek to avoid the probate courts. And in general, I guess if you're if you're young and in good health, a simple will may be all that you need. But if you have a little property, you may want to spend your time planning to avoid probate. If you're older, in ill health, or own a significant amount of property, you'll probably want to do some planning to avoid probate. And you can do this through some of these means that we've identified, such as trusts that allow you to create a separate legal entity in which you can own all of your property, gifting, joint ownership such that maybe like a checking account or savings account, a transfer on death where maybe an investment account goes automatically and bypassing probate right to the beneficiary. Payable on death accounts that are common within banks and credit unions, and retirement plan beneficiaries. So we've heard this phrase executor, but really what is an executor? An executor is a person with administrative responsibility charged with settling your estate's affairs. Essentially, the executor's job is to protect the deceased person's property until all debts have been paid and to see that what's left is transferred to the right people. The law does not require an executive to be a legal or financial expert or to display more than just reasonable prudence and judgment. So some of the tasks will include deciding whether or not probate court proceedings are needed, figuring out who inherits what property, if probate is required, filling out any of the forms that are necessary, finding the deceased person's assets and managing them during the probate process. Now again, maybe 9 times out of 10 this is just all well and good, but I specifically have heard of a number of cases where families have broken up or haven't talked to each other in 20 years because one of the children was named the executor and the other 3 completely disagreed with everything he or she had to say. So I guess, it can tear a family apart without a doubt. And I've seen that personally. So what is a trust? Trusts have these kind of lofty, scary personas, but all they really are is another tool within your estate plan. A trust is a document that you establish with the help of your attorney, and it's nothing more than a legal arrangement in which you, as the owner of your estate, and as you, as the trust grantor, would transfer the legal title of that estate to somebody else, the trustee, for the purposes of benefiting one or more third parties, the beneficiaries. The trustee, who may be a person or corporation, is given title to the property in accordance with the terms of the trust agreement. Perhaps the biggest benefit of trusts is that they allow the beneficiaries to enjoy property ownership while minimizing their tax exposure. It's also very useful in protecting assets. So if I own my house and I put it into trust and I have insurance and somebody trips on my proverbial sidewalk and they sue me, but they sue me for in excess of my insurance coverage, well, now maybe I even have an umbrella policy and maybe it exceeds that. Well, it makes it difficult for that individual to try to attach my trust-owned assets because it may be under a completely different tax ID. It's under kind of a different ownership. So it creates that wall between me and the asset. It can avoid probate. Probate, again, may not be that big of a deal, but also probate is not private. Probate is public. Trusts, the execution of a trust upon death is private. Nobody knows what happens. With probate, those documents, including the will, are registered at the local county courthouse. So hypothetically, you could have someone go to the courthouse and find people who have inherited money and then go out and try to convince them to invest in some wild investment schemes. So if you've got a child like that, you may not want your estate to go through the probate process. Trusts usually are broken down into two different general categories. One is revocable, and the other is irrevocable. Revocable trusts are sometimes called living trusts, and they can be changed or revoked at any time. Most revocable trusts become irrevocable at the death or disability of the grantor. Now, irrevocable trusts cannot be changed once they are set up. The assets you place into an irrevocable trust are permanently removed from your estate and transferred to the irrevocable trust. Income and capital gains taxes on assets in the trust are paid by the trust, and upon your death, the assets in the trust are not considered part of your estate and are therefore not subject to estate taxes. So again, this is a tax strategy to distance your assets from yourself to mitigate the tax implications of your estate upon your death. So one of the most effective methods of avoiding probate is to set up a living trust. You must remain trustee during your lifetime, and the formal title to the assets is transferred to you as trustee, and you must maintain control of these assets. Upon your death, the assets are transferred to beneficiaries without the inconvenience or the cost of probate. Some people will sometimes call a living trust, they'll call it a will substitute. One of, again, its advantages is that your assets move to your heirs without having to go through probate. And in addition, a living will is, as I mentioned, private, while probate is a public process. Real key thing here is I've seen people go out and go through the effort of putting a trust together and pay for it and everything, and then guess what? They never get around to retitling their assets. So unless those assets are retitled in the trust, they will not receive any of the protection benefits of the trust. So putting the trust together is just one thing. Secondly is retitling any of your assets, like your house, your car, non-retirement accounts, etc., your collectible, your coin collection, etc. They must be retitled into your trust. Now, there's also many different types of trusts. Some general types are like life insurance, trusts for minors, qualified personal residence trust, and charitable trusts. When you're considering trust arrangements, remember that there are many options and many tax considerations. So we mentioned that life insurance trust objectives are to get assets out of your estate so that they're not subject to maybe estate taxes upon your death. Trusts for minors are money set aside to be assured that that money is going to be used exclusively for the benefit of the minor children and not used frivolously by the caretaker, who may be a relative. Qualified personal residence trust, trust put together to ensure that a residence is maintained maybe for someone who is incapacitated. And then charitable trusts, set up so that you as a retiree perhaps receive the income from monies that you have donated to trust. So you donate it to the charity. So you have donated that charity, that money to the charity. Now it's no longer part of your estate. but you get to keep receiving the interest dividends that it's generating until you pass away. So you get a tax deduction now in exchange for donating that money today, per se, and then passing it over upon your death. So again, what would happen? We talked about this if you couldn't handle your affairs. What happens if you become capacitated and couldn't handle your bills, your investments, paperwork, insurance, benefits, etc.? Who would make these arrangements for your medical care and see that your wishes for treatment were carried out? Fortunately, there are legal arrangements available, such as powers of attorney and healthcare directives, that allow your affairs to be managed by people you choose. If you were to become incapacitated without choosing someone to manage your affairs, a court would decide that for you. So that kind of leads us back to the infamous Terry Schiavo case down in Florida a number of years, probably got to be 10, 15 years ago now. But this was a woman who had a relatively young and healthy, I think she was in her 20s, suffered a heart attack. They managed to revive her. However, she suffered from oxygen deprivation of the brain and was considered to be in a persistent vegetative state. One set of family members said she would never want to live like this and moved to have her feeding tube removed. And another member of the family said, oh, no, we want to try some life-saving therapy. And she actually had her tube removed and reinstalled and then removed again, and she finally had it removed and passed away. But this went on for, I want to say, 6 or 7 years. So think about all the grief and anguish that had to occur, and the division of the families because there was no upfront designation. She could not state what her wishes were. So if you have children who are 18 years old, so you think, well, gosh, they're not minors. Well, yeah, but, you might want to check to see if the state in which you live has provisions that are consistent or not with what you think your child might want. One child might want to be kept alive at all costs, and another child might not. So even though they don't have a lot of money to take advantage of the trusts and tax advantages, etc., they might take advantage of nothing else but specifically an expectation of what will happen if they become incapacitated, in a coma, persistent vegetative state, etc. So a power of attorney it just gives another person legal authority to act on your behalf. This person becomes known as your attorney in fact, or sometimes it's called your agent. The typical power of attorney will take effect when it is implemented. However, many states permit a conditional power of attorney that goes into effect only when a specified event occurs, such as incapacitation. Banks or other financial advisors often serve in this capacity, and the power of attorney agreement ends at your death. This means that your attorney, in fact, cannot handle things after your death unless you also name this person as your executor to handle them after your death. Now, I have a private, if you will, trustee that I got a call from today who needed some money, and this is a client of mine. Well, a client of mine knew that he and his brother were going to be at odds of how money got, and the parents knew that they had two sons. One son who was very responsible, one son who was a spendthrift, got into all sorts of bad activities, legal and otherwise. So with the one son, they said, we're going to bequeath X amount, half of our estate to you, and you are free to use it as you see fit. However, for the other son, they brought in a trustee to manage the estate. And so if the son needs any money, he has to, for lack of a better word, come in and kind of request it and petition as to why he needs it. Is there an unusual circumstance that's going on? You know, did his car break down? He can't just get at it anytime he wants. So just kind of, again, I'm seeing the topics that we're covering here today. I'm seeing them on a daily basis. So secondly, to the power of attorney per se, what is a healthcare directive? This is a legal document that spells out your wishes about medical treatment. And the directive essentially creates a contract with the attending doctor. Once the doctor receives a signed and witnessed directive, he or she is under duty to honor its instructions or to make sure the patient is transferred to another doctor who will. Healthcare directives vary from state to state, so check to find out the types of directive your state allows. That's another kind of interesting thing that I hear about now and again is, you know, I hear about people going to these hospitals and these hospitals having these 7 wishes, you know, but I guess the problem there is the 7 wishes would only take effect at that hospital or one of its legal partners, but what if you're at a completely different hospital? So I'm not a big fan of trying to do these 7 wishes for only one hospital when you don't have no idea which hospital you're gonna be in. What is a conservatorship? It's a legal arrangement in which the court gives authority to an adult, known as a conservator, to manage your financial affairs. You would be considered the conservatee. Now, most states give preference to the conservatee's spouse, adult children, adult siblings, or other blood relatives, but a judge has flexibility and may use his discretion to pick the best person for the job. A conservatorship is permitted only when someone is so incapacitated that he or she cannot manage their personal financial affairs. These are typically established for people who are in comas, suffer from advanced stages of Alzheimer's disease, or who have a serious illness or injuries. So once you decide to create an estate plan, where should you start? Well, a good place to begin is to collect the necessary documents and information. These include any will and or trust documents you already have, birth and marriage certificates, and an inventory of your assets. Next, you should think about how you would like to distribute your assets, your objectives, the size of your estate, and state and federal tax laws are major factors that affect your plan. Each decision you make will have a variety of legal and tax implications. So you should seek the guidance of an estate planning an attorney. I emphasize this, an estate planning attorney, with no disrespect, not to just an attorney who practices law. Estate planning is very, very unique and requires that specialty. So same as in the medical profession, you wouldn't go to a general practitioner for open heart surgery. There's a multitude of sources available that provide information on estate planning, and these include books, publications, and websites. So you can read up on this a little bit, and again, you could look for trade organizations such as the National Association of Estate Planners and Counsels, so NAEPC, which may be a good first source for you to go to. So today we've looked at some of the importance of creating an estate plan and to ensure that your family and loved ones have access to your property. Now that you're familiar with these basics, I really encourage you to start planning. None of us knows what the future has to store. It makes sense to organize your estate now. So I'd really encourage you to take that to heart and think about getting that pulled together, as soon as possible. It's not really that expensive, and you can usually have it pulled together, kind of one time. And then if down the road something needs to change, you don't have to, pay the hundreds or whatever of dollars, thousands, depending on how complex your estate plan is, over and over again. You can do it one time, and then changes can be handled with addendums or attachments. So I just wanted to quickly share with you and say thank you. Well, first of all, say thank you for joining me. I really appreciate it. If you have any questions, you're welcome to give me a call at your convenience. I hope you've learned a couple things here. I also wanted to share with you that I did record this webinar. So you're looking at my website right now. In the upper right-hand corner, you can see this little YouTube icon here. So if you click on that YouTube icon, it'll take you to my YouTube page. And here you can see some of the past webinars I've done on cash balance plans, protecting wealth, college savings, and so on. So probably tomorrow I will have this webinar. I will upload it to my YouTube channel. So if you'd like to go back to it again and rewatch it, or hit a couple of key points that maybe ran past you, this YouTube channel will be here for you fundamentally forever. So again, with that, I'll say thank you very much for joining me. I'm going to sign off now. If you have any questions, please don't hesitate to give me a call, send me an email. I'll be happy to answer any questions you might have. But I like to do those on a one-to-one basis. Thanks.